Welcome, and thank you so much for coming. This is the Volk lecture, the distinguished lecturers, although we're hoping that today will be more of a conversation than an actual lecture. But the lecture series was established in 2004 by friends and colleagues honoring Stephen Volk, who was class of 1957, and chair of Credit Suisse, First Boston, and formerly from Shearman and Sterling. And we have this lecture every year in connection with Law Day. And Law Day is actually a national day set aside to celebrate the rule of law, and it happens every year on May 1st, so it's not May 1st, it's May 2nd, but that's okay. Law Day provides an opportunity to understand how law and the legal process protect our liberty, strive to achieve justice, and contribute to the freedoms that all Americans share. And this year's Law Day theme, which again is set nationally, is free speech, free press, free society. It focuses on these cornerstones of representative government and calls on us to understand and protect these rights to ensure, as the U.S. Constitution proposes, quote, the blessings of liberty for ourselves and our posterity. As always, this lecture is one of the funded lecture series that's in connection with the Dartmouth Lawyers Association, and so we thank them, as always, for their generous support of our Law Day celebrations. And they also sponsor other law-related lectures throughout the year. And this afternoon, we have two members of the Dartmouth Lawyers Association in the audience, Tom Skilton, who's class of 1989, and he is the current president of the DLA, and Bill Kennedy, who's class of 1971. So we are incredibly honored this afternoon to have with us Nadine Strossen, who is the John Marshall Harlan Professor of Law at New York Law School. She has written, taught, and advocated extensively in the areas of constitutional law and civil liberties, including through frequent media interviews. You may have seen her there. She, from 1991 to 2008, she served as the president of the ACLU. She was the first woman to actually head the ACLU, which is the nation's largest and oldest civil liberties organization. She's currently a member of the ACLU's National Advisory Council, as well as on the advisory board of EPIC. EPIC is the Electronic Privacy Information Center, FIRE, which is the Foundation for Individual Rights in Education, and she is a member of Heterodox Academy. She is here to talk about her most recent book, Hate: Why We Should Resist It with Free Speech, Not Censorship. It was published by Oxford University Press in May 2018, so a year ago now. The book has actually just been chosen as the common reading of Washington University in St. Louis, which is really exciting. In 2017, the American Bar Association presented Professor Strossen with the Margaret Brent Women Lawyers Achievement Award, which celebrates the accomplishments of women lawyers who have excelled in their field and have paved the way to success for other women lawyers. The National Law Journal has named her one of the, quote, 100 most influential lawyers in America. This goes on, she's very impressive. Vanity Fair has named her, has included her in America's 200 most influential women, Ladies' Home Journal, among America's 100 most important women, whether 100, 200, it sort of varies. Upside Magazine included her in the Elite 100 executives leading the digital revolution. She has made thousands of public presentations before diverse audiences, including on more than 500 campuses and in many foreign countries. So she is very much accustomed to speaking on college campuses, to student groups, and to all sorts of folks. She's commented frequently on legal issues in the national media. She's appeared on virtually every national news program, and she has been a monthly columnist for 2 online publications and a weekly commentator on the Talk America radio network. And I love this little piece of information. In October of 2001, she made her professional theater debut as the guest star in Eve Ensler's award-winning play, The Vagina Monologues, during a week-long run at the National Theater in Washington, D.C. So thank you so much for being here. And we're going to move over here. We're going to kind of run this as a conversation. I am going to open things up and kind of get things moving, and I have lots of questions of my own, but our hope is actually that we can fairly quickly move into a more interactive dynamic with all of you. And so also because I have back problems, it also gives me an excuse to stand up and walk around the crowd with a microphone instead of sitting in a chair. So hopefully you will feel free to join in at any point.
Thank you so much, Julie, for that gracious introduction. And this is at least my third visit to Dartmouth. So among those 500, I'm very happy to have included you multiple times. And the last time was not that long ago. It was in the fall of 2017.
Oh, so
yeah,
really pretty recently. Huh. There's also some very fortuitous, or I thought fortuitous, timing of today's talk, because just maybe an hour and a half ago or so, I got a Washington Post push notification come through my phone, maybe some of you got it too, that said Facebook bans far-right leaders Louis Farrakhan, Alex Jones, and Milo Yiannopoulos for being, quote, dangerous, which sort of fits in absolutely perfectly with what we are going to be talking about. So
let's just get started. I mean, the main problem with going beyond what U.S. law allows to be censored as hateful speech, and I'll come back to that because our law is so poorly misunderstood. We often hear two opposite but equally incorrect generalizations, either that hate speech is not free speech, which we often see signs saying that on college campuses, but we also hear public officials saying that. We also hear hate speech is protected free speech, and neither generalization is correct. Our law draws a very sensible line and says speech with a hateful content may not be punished or regulated just because of dislike of its ideas, no matter how loathed the ideas are, by no matter how many of us, and no matter how strongly we revile those ideas. Government may not suppress speech based on its content, viewpoint, message, or ideas. As Oliver Wendell Holmes famously said, we have to respond, the freedom of speech belongs most importantly to the idea that we hate. We should respond, explain why it's hateful, explain why people should not adhere to it. However, if you move beyond the content of the speech to context, the Supreme Court has correctly said that if speech with a hateful content in a particular context directly causes certain imminent, serious, specific harm, then it can and should be punished. And this is often summarized as the emergency principle. If the speech in context, under all the facts and circumstances, presents an emergency of imminent harm, such as a true threat or intentional incitement of imminent violence or targeted harassment or bullying, then it can be punished. So our law is really very sensible. Now I've wandered so far away from your initial question, but I remember what it is. If we go beyond that, and by the way, let me summarize. To satisfy the emergency principle, you understand that there has to be a tight and direct causal connection between the speech and some specific serious harm. That is not to say that speech that doesn't satisfy that standard is not potentially harmful, or to eliminate the double negatives, speech can indirectly, perhaps at some time in the future, cause harm. And that approach, which we used to follow in this country and which is still followed in countries all over the world, is usually referred to as the bad tendency test. But when you think about it, all speech could satisfy that standard because, as Oliver Wendell Holmes also said, every idea is an incitement, right? It might persuade people to adopt dangerous ideas, to use the Facebook word that you quoted, which might lead them to engage in dangerous conduct. But that is such a subjective standard, it can apply so sweepingly that if government gets that power, or if Facebook arrogates to itself that power, then no idea is safe. And we can predict that that discretionary power is going to be used to silence minority opinions, minority voices, those who criticize the government, those who are seeking social change. And what I found as I did the research for my book was that human rights activists all over the world have been clamoring to end the bad tendency approach and the suppression of ideas just because they are hated or hateful, to move more in the American direction, and not because of free speech principles in their countries. Their countries do allow censorship of hateful speech based on the content, but because the censorship is ineffective at best, counterproductive at worst in promoting the goals that I completely share with those who advocate censorship, namely equality, dignity, diversity, inclusivity, societal harmony, and individual well-being. So I'm very troubled by this very subjective standard. I may not like the ideas that are being propounded by these individuals, but I have to tell you, other ideas that have been denounced as dangerous include Black Lives Matter activism, pipeline protesters, I'm mentioning some ACLU clients here, anybody who is protesting government abuse, including abuses within the criminal justice system, basically people who are trying to criticize the powers that be.
Yeah, we're sort of hovering around the edges, but just to make it explicit, why write this book right now? This is clearly an issue that has been a passion issue for you for a very long time, but why this particular book right now?
I actually started working on it in terms of generating the book proposal back in 2015 and 16, which was exactly when we saw the rise of campus activism in response most immediately to the killing of Michael Brown in Ferguson, and that led to student protests not only at the University of Missouri, but all over the country, including obviously right here on your campus. As somebody who had been a social justice warrior, and I know critics use that as a condemnatory term. To me, it's a badge of honor. I was a social justice warrior in my day on some of the same issues. Sadly, we haven't made enough progress for those issues to go away. And so, and then in between, there was a lot of passivity on college campuses. Surveys showed that students were mostly apathetic and uninterested in public policy issues, weren't even interested in paying attention to the news, let alone becoming more actively engaged. So I was thrilled at this resurgence of campus activism. I and the ACLU had been crusading against police abuses and especially the targeting and unjustified killing of young, dark-skinned men for many decades. And it was wonderful to finally see a lot of public traction around an issue that we had pretty much been a voice crying in the wilderness, and also the activism against sexual violence and for immigrants' rights and LGBT rights. This was so wonderful, but at the same time, there was escalating a sense through anecdotal experience and through surveys that so many campus activists, faculty as well as students and members of the general public, were becoming more and more hostile to free speech, seeing it as the enemy of their causes, our causes, I can say, as opposed to what I had always believed it to be, namely a time-tested and essential ally. And it was clear to me that neither I nor anybody else who had been advocating that position for a long time had done so with sufficient persuasiveness. And I'm an advocate and I'm an educator, so wearing both of those hats, I really leapt at the opportunity to try to make the case more persuasively. And if I can also throw in a personal word, Julie, because I think all of us have some personal connections to these issues. How could we not? I really became very, very concerned about the increasing prevalence of hateful rhetoric and hateful crimes and discriminatory conduct of every sort, not only in this country, but all over the world. And the personal connection for me is, I mean, the most immediate personal connection is that my father, who was born in 1922 in Germany, was a Holocaust survivor. He was in the Buchenwald forced labor camp. He was young enough and healthy enough when he was sent into the camp that the Nazis did not immediately target him for extermination. I know that's a terrible word to use. Somebody told me I shouldn't use it because it sounds like something you use against vermin, but that's the Nazis' image of Jews. They did use, so that to me, that's described, that's how they saw it. That's what they were trying to do. My father escaped that fate initially because at the time that he went in, he was still young enough and strong enough and healthy enough that they could use him for back-breaking, soul-crushing, forced labor. But the conditions there were just horrific. He almost died of pleurisy, and most directly relevant to me, he, as an undesirable, was slated to be sterilized by the Nazis. And literally one day before his scheduled sterilization, the camp was liberated by the US military. So I always like to pay my enormous respect to the military, and let me take the opportunity. It should go without saying, but nothing goes without saying these polarized times. The people who commit police abuse, I know, are a minority, and the vast majority of those who are in law enforcement, military, every occupation, are so brave and so dedicated and take an oath or affirmation to do what I'm trying to do, which is to protect our constitutional values.
So as part of that story, how you got to law school?
Yes, I definitely went to law school hoping to use law as a way to bring us closer to our national ideals, which we were far short of at the time that Thomas Jefferson penned the Declaration of Independence, but I think we really have to give credit. It was the first nation that even aspired to liberty and justice for all. And to the credit of the framers for all of their shortcomings, they created a government structure that permits constant improvement, in part through the amendment process. And the vast majority of constitutional amendments have added to those of us who were excluded from the original Constitution's concept of we the people, so really making more and more a reality of what had initially been ideals only. And I went to law school hoping I would be able to use my law degree to continue that progress, and I'm very happy to have been able to play a part in doing that. We're much closer now than we were when I began law school, and certainly then when I was a child, we still had racial apartheid by law in this country. The Supreme Court had never recognized that even when I was in law school, I mean, it dates me, but still it's not ancient history, the Supreme Court at that point had never recognized that the Constitution's completely open textured equal protection guarantee had anything to do with gender equality. I'm very proud to have worked with Ruth Bader Ginsburg, who was the founding director of the ACLU Women's Rights Project, that finally persuaded the Supreme Court to read that, to me, undeniable meaning into the Equal Protection Clause. And I'm very happy, you know, on the issue of LGBT rights and marriage equality. Way back in 1970, well, actually the case started in the 1960s, the ACLU in my home state of Minnesota brought a lawsuit making the outrageous, that's what we were told, claim under the Equal Protection Clause that there should be a right for two men to marry each other. And the Supreme Court's reaction to that lawsuit, it reached the Supreme Court in 1971, so we were generations ahead on this issue. The Supreme Court dismissed our case for want of a substantial federal question. They said it doesn't even present a substantial question. So I was so delighted when they finally reversed that decision.
Yeah, it was a very short opinion.
Yeah.
I see no constitutional issue here.
Yeah.
So how did, we kind of covered this in my class a little bit earlier, but so how did you make your way to the ACLU and specifically to the First Amendment and to speech?
I have had an instinctual support for free speech. I've loved to exercise it ever as far back as I can remember. And I just had an instinctual sense that I should have the right to dissent and to protest. And I was constantly being told by authority figures to basically shut up. And so when I discovered that, and quite frankly, in those days, this was also before the Supreme Court held in another ACLU case, I'm proud to say, that students have First Amendment rights, including in schools. In 1969, in a case called Tinker versus Des Moines School District, the Supreme Court held for the first time, the Constitution does not stop at the schoolhouse gate. So I first heard about the ACLU, to the best of my knowledge, to the best of my recollection, the first time it really made an impression on me was when Ruth Bader Ginsburg was a guest lecturer at my law school. Early in my law school career, she had just founded the ACLU Women's Rights Project. And when she explained why it was that she chose the ACLU as the base for her advocacy for women's rights, a cause that was very, very important to me. And I was very involved in the women's rights movement. When I was in college, I was very involved in the reproductive freedom movement. When I started college, again, ancient, not ancient, but long ago for many of you, it was 1968, and there was I went to Harvard. There was a prosecution going on in Boston at the time of a doctor. He was being criminally prosecuted for having performed a life-saving abortion on a woman. And interestingly enough, he was African American, which I don't think is a coincidence. He went on, Dr. Kenneth Edelin, he went on to become the president of Planned Parenthood a couple decades later. But anyway, so when Ruth Bader Ginsburg explained that she wanted to situate the cause of women, she had many reasons for taking her activism to the ACLU, but the one that resonated with me in this context was she really wanted to make it clear that women's rights were an integral part of the overall universal human rights agenda. And that's very much my own holistic approach. So I'm very supportive of the ACLU's unique mission to defend all fundamental freedoms for all people. No matter who you are, no matter what you believe, you are entitled to certain fundamental rights merely by virtue of being a human being. And I really do believe that all of those rights are indivisible, and that's why I'm completely committed to defending freedom of speech, even for ideas that I loathe, because I know if we don't do that, then the power to suppress those ideas is going to be used to suppress ideas that I love.
Yeah, one of, I think it's no news probably to any of this room, but the ACLU has frequently come under critique for defending unpleasant parties. And in fact, there's a fair bit of amount of controversy within the ACLU organization itself right now as a result of the Charlottesville incident and the role that the ACLU played in that. And I wondered if you could talk a little bit about that.
Absolutely. Although I have to say, as kind of, to me, a rough indication that we're doing our best to neutrally defend all fundamental freedoms for everybody, including those who espouse the ideas that we hate. We have been subject to a lot of criticism, mostly from the right of center spectrum, portion of the spectrum, that we're supposedly not sufficiently vigilantly continuing to defend freedom for conservative or right-wing ideas. And then there are others who are saying we're doing too much of it. So. But there was even before Charlottesville, long before Charlottesville, probably the single most controversial case the ACLU ever handled is the so-called Skokie case, which was factually very similar. It goes back to 1977 when we came to the defense of freedom of speech in the context of neo-Nazis who were demonstrating in Skokie, Illinois, a Chicago suburb that has a large Jewish population, and even more poignantly, back in 1977, a very high percentage of Skokie residents were Holocaust survivors. And it was a slam dunk winner in the courts of law. The case went all the way up to the US Supreme Court because of the principle that I talked about in response to your first question, the idea of content neutrality or viewpoint neutrality. The mere fact that we loathe their viewpoints and that their viewpoints are loathsome is not a justification for suppressing it. And by the way, that principle is completely uncontroversial among the justices. Not a single justice in modern time, no matter what their disagreements on so many other issues, they're unanimous on this point. And they've called it the bedrock principle of our free speech jurisprudence. But as easy a case it was in the courts of law, it was a very hard case that we actually lost in the court of public opinion. And not only the general public, but even card-carrying members of the ACLU, people who felt so strongly about freedom of speech that they spent, and by the way, it's still only $20 after all this time, just advertising here, that they resigned. We lost 15% of our members nationwide. And we quite quickly recouped that because many other people said, you really are being true to your principles, you're not just another liberal organization. But it's the same, it's sort of like deja vu all over again, to quote Yogi Berra in 2017. We again came to the defense of the principle that you should be entitled to free speech no matter how loathsome your ideas are. And that was implemented in Charlottesville. And again, it only went to one level of court, but the judge agreed with us that there was no justification based on the evidence that was available at the time, no indication that there was going to be any threat to public safety, and that the only reason that the claims of public safety concerns the judge determined were pretextual. It was dislike of the ideas that were really motivating the city council. And I do have to say this, Julia, that There was a report that was done by the city council, or at the behest of the city council in Charlottesville after the catastrophe there. Nonpartisan, they retained a very respected law firm to do a very detailed report, and it really is extremely condemnatory of law enforcement at every level. Just a complete failure to do their job of protecting public safety. I've been there several times, and I've seen the place where Heather Heyer and others were mowed down. In that entire vicinity, there was not a single law enforcement officer on duty. And it was a complete failure of training, of communication, of coordination, of starting, the FBI, the state police, the county police, the city police, the university police. And a number of those officials were forced out of office as a critique of their failure. And I have to say, that's, going back to Nazi Germany, R.A. Nyer, who was the executive director of the ACLU at the time of the Skokie case, was himself a Holocaust survivor. His extended family, he came from Germany, his extended family was completely exterminated, to use the Nazis' vernacular. He escaped with his immediate family, and he wrote this wonderful book after the Skokie case called Defending My Enemy. And in that book, he's such a devout champion of free speech. He went on to become a towering leader in the international human rights movement. And so many people are shocked that he would say this because they so associate him with strong defense of free speech. But he said in that book, much as I love free speech, I loathe the Nazis even more than I love free speech. So if I were convinced that censoring hate speech, censoring the Nazis would have prevented their rise to power, I would have been all in favor of it. And then he goes on to discuss the historical record, which most people are ignorant of. There were very strong anti-hate speech laws in the Weimar Republic during which the Nazis rose to power. And the laws were very regularly enforced. The leading Jewish organization at the time said the prosecutions are by and large fair and being handled capably, but the Nazis loved it. It became a propaganda platform for them. They got attention they otherwise never would have, and sympathy they otherwise never would have. And that's the same strategy that's being followed by the white nationalists here. And I don't mean to compare them in other ways. They're not advocating genocide. But we unfortunately, unwittingly play into their strategy by trying to suppress them.
I want to make sure that we are allowing for an opening
Yes.
up questions. So this will also let me stand,
Oh, yes.
which is also exciting for me. I'm gonna go. Oh, please, absolutely.
Welcome.
Welcome. And then there's a mic. Where are the mics? Aha. Awesome.
Take low, I take high.
Okay.
Hi.
All right, you take
Hi.
high. There's
Nice to see you.
right there.
Hi. Hi.
Go for it.
Yeah, we've always had a view that the marketplace of ideas is where good decision-making is going to come. And it seems like the problem maybe isn't so much speech, but it's sort of the breakdown of the marketplace of ideas. We now have people who are totally disregarding factual information or making up their own facts. And it seems like this sort of tenet that was so critical to how we would be able to move forward as a society has really broken down. How are we going to, how do we retain free speech and also the critical idea that the marketplace of ideas is supposed to work and the best ideas will rise to the top?
Actually, Oliver Wendell Holmes, who was the one who first put into play that metaphor of the marketplace of ideas, he was deeply skeptical, and he never said it's any guarantee that the best ideas are going to rise to the top. He just saw it as a less bad strategy than empowering the government to pick and choose which ideas were true and which ideas were hateful and which ideas should be allowed or not allowed. And I continue to submit that that is the analysis that's relevant today. For all of the flaws in the marketplace of ideas, for all of the problems that you point to me, the worst fix would be giving government power to decide what news is fake, right? And I'm not saying that just because I know what Donald Trump considers to be fake news. I would say that regardless of who is in power, at any level of government, I would rather, for all of its imperfections, trust my fellow citizens and their free speech rights to engage in debate. Now, there's a wonderful report that was just done by a terrific organization called PEN America. It's an organization of writers, and they advocate for free speech, and it's about fraudulent and fake news. And they talk about how the best way to deal with that problem is through education, that we absolutely have to educate and empower every single one of us, starting at a really early age, in media literacy, critical reading skills, being able to do fact-checking, our research, because the internet also provides unparalleled opportunity to go to original sources and to including fact-checking sources to sort the true from the false.
Hi, thanks for coming.
Thank you.
So you talked a lot at the beginning about the constitutional requirement that the government not step in and punish for certain types of speech. But it was in the context of a question about Facebook, which is not the government. So if a company like Facebook or YouTube bans things that they deem as hate speech, do you see that as a problem or as being unconstitutional? And furthermore, if you do, and you would like to see them stay on those platforms, what do you view of like the demonetization of them that effectively censors them but doesn't literally censor them?
Okay, I'm not sure I understand the second part of the question, but thank you so much for the question, and I'll do my best. And I was not suggesting, so let me start with some basics here that the questioner, what's your name, by the way?
Mark.
Mark, that Mark obviously knows, but many people are surprised to learn, which is that the Constitution, including the First Amendment free speech guarantee, only applies to the government. So you have no First Amendment free speech rights against Dartmouth, not that Dartmouth would ever violate anybody's free speech rights, and you certainly have no free speech rights against any private media company, whether it be the New York Times or whether it be Facebook. To the contrary, as Mark recognizes, they have their own free speech rights, which certainly include the right to pick and choose what they are going to publish and what they're not going to publish. What I was attempting to point to, and thank you for giving me an opportunity to clarify it, Mark, is that the basic reason why I don't trust government to enforce hate speech laws transposes exactly to my distrust of powerful private sector entities making that determination, because it is inherently, inescapably subjective determination. One person's dangerous or hateful speech is somebody else's cherished and loving speech. You know, I gave the example of Black Lives Matter, which I happen to think is very positive, but has been denounced as supposed hate speech, including by government officials, including by the FBI and others with law enforcement power. So Facebook and other social media companies have been following the Same pattern that has been observed by governments all around the world and in our own country until we had strong protection of free speech, which is that disproportionately censored are the voices of the very minority groups and perspectives that are hoped to be protected by hate speech laws. Here's an article from USA Today, a very long feature story from April 24th, so just about a week ago. And the title, which is very chilling but accurate, Facebook While Black, subtitle, users call it getting zucked, say talking about racism is censored as hate speech. And I learned through my research that many civil rights activists actually use the term racebook to convey that every time they're trying to denounce hate speech or seek support or argue against police abuse of minority people, that they get taken down for violating hate speech. And I'm using Facebook as an example. The problem is ubiquitous. So so the question is, what do we do about it? I'm not sure what, I think I've answered the first part of your question. Now, can you tell me the second part of your question?
Yeah, the second part was that even if, say, Alex Jones was allowed to be on YouTube, YouTube would demonetize Alex Jones and not allow advertisers to be on his channel.
Right.
Which would, he does have private endorsements, but in a case where one doesn't, it would effectively censor someone.
Exactly, I agree with that.
And I was just curious what your opinion is on like effective censorship without literal
I think
censorship.
I mean, and again, I'll use the First Amendment standard, not because it applies, but because I think it's correct and reflects the appropriate policy analysis that I would want to bring to bear in the private sector as well, which is anything that has the practical effect of stifling or chilling speech is considered an abridgment of speech. So this is a way of abridging speech. Let me give you an example from my state of New York. The governor there is very hostile to the National Rifle Association, and I'm not a fan of the National Rifle Association particularly, but it has free speech rights and free association rights, and Cuomo has allegedly, according to a lawsuit which has alleged evidence and support, put pressure on regulators in New York to in turn, regulators of insurance industry and of banking and financial services, pressured them not to do business with the NRA. So that's not direct censorship, but the impact, if you can't get basic financial services or insurance, you can't advocate your message. And the ACLU has filed a brief in support of the First Amendment, again, very controversial, and if so much dissent that the New York branch of the ACLU didn't join us in that and oppose it. But I think the national organization is right, because another administration could come along and say, put the same pressure on banks and insurance companies, don't do business with the ACLU or with Planned Parenthood. So you're absolutely right that we have to be very concerned about that. Now the question is, what legal tools do we have available since we don't have the Constitution and the First Amendment? And that's a much harder question.
Hi, actually, is it okay if I have two questions? One can be brief, one can be longer.
I give you permission.
Okay, great.
But the question is other people. But
my name is Tom.
Hi, Tom.
The question I have is, we hear a lot that protecting free speech essentially helps minorities to advocate for their positions. What are your favorite historical anecdotes for that happening in the past in the United States?
Well, I don't even, is it okay if I give you a present example?
Sure.
I mean, the first historic example that occurs to me is Martin Luther King, right? Why did he write his historic letter from a Birmingham jail? Do you know what he was in jail for? For trying to exercise his free speech rights. It's shocking for us today, but his ideas were considered hateful, definitely dangerous, subversive, unpatriotic, treasonous, communist, which was that day's equivalent of terrorist, right? And every speech suppressive law in the books was used against the civil rights movement. Move forward, and by the way, it's no coincidence that the Supreme Court's great free speech decisions came completely in the context of the civil rights movement. It was the Warren Court that was very sympathetic to the cause of racial justice, and they started overturning negative free speech precedents that had been created in the Cold War and the Red Scare era. And you know, it's a color metaphor. I hope I don't offend people, but I'm going to exercise my free speech rights. I'm going to quote a book that was written in 1967 by University of Chicago professor, and he said, the blacks won back for us the free speech rights that the reds lost. In other words, it was specifically to empower African Americans that the court suddenly breathed life into free speech that it deliberately was had taken away from communists in an earlier era. But let me tell you about the Supreme Court's most recent hate speech case, because even though it has been illegal to have hate speech laws, they continue to be on the books. As we were talking about in Julie's class, you know, the fact that something is illegal doesn't mean it doesn't happen, so you have to keep fighting the same battle over and over. And this is a case from 2017, unanimous, as these cases have been, involved a provision in the patent and trademark statute that denied trademark protection. You probably know, Mattel versus Tam. So Simon Tam is an Asian American rock musician. His entire band were Asian American men. And they deliberately chose, I'm going to give you a trigger warning, as the name of their band, an ethnic slur, a word that traditionally had been used as an ethnic slur, but they wanted to reclaim it to assert their pride in their Asian heritage. So they called their band The Slants, and that was essentially considered hate speech under this statute that said any term that's disparaging or degrading, classic hate speech code language, on the basis of race or ethnicity, you can't trade name it. And when that was struck down unanimously by the Supreme Court, it was simultaneously recognizing Simon and his bandmates' individual freedom, but it was also recognizing their dignity and equality as Asian Americans.
My second question, so I don't literally have my card with me, but I can assure you that I am a member of the ACLU and a pretty passionate one at that.
Thank you.
But I have to say, I was very critical of the ACLU's decision, and correct me if I'm misstating their opinion on this, was that they were going to, and this kind of goes off your Cuomo claim, that they were going to not provide legal assistance to groups that were hoping to exercise their Second and First Amendment rights in tandem. I believe it was the open carry cases that had happened. So I believe the position of the ACLU was that for groups that planned to march with open carry firearms, they were not going to provide legal assistance to those groups. Is that correct characterization?
Please remind me of your name again.
Tom.
Tom.
Yeah.
Tom, I don't think that's correct. If you're talking, so there were new, but first of all, let me say this, that no thinking person could possibly agree with 100% of what the ACLU does. We covered so many issues and so people can disagree on principles, especially when there are conflicting civil liberties principles at play. We have many cases that involve conflicts between privacy and free speech, for example, or religious freedom and separation of church and state. So there's disagreement at the level of principle, but there's also disagreement, even if you agree on the principle, how does it apply in a particular factual situation? And one of my colleagues long ago said, if you agree with 80% of what the ACLU does, you should be a member. If you agree with 50% of what we do, you should be an officer. You know, you get it, right? The more you think about it, the more complicated it is. But so new guidelines were issued as a result of a consultative process after Charlottesville because of the uproar that Julie mentioned. And you know, how can an organization that defends dissent do anything other than constantly re-examine when new arguments or even when old arguments are made? Of course we have to grapple with them. And I've read those guidelines, and I was actually quite surprised because I had read press accounts that seemed to say that we were making a categorical exception for people who were exercising their Second Amendment rights by carrying firearms. So I read the guidelines and I saw, no, that is just a factor of the many factors that we will consider, because deciding when speech becomes a true threat and satisfies the emergency exception is highly fact-specific and contextual. So we listed a lot of factors that would be considered, one of which was, are they carrying firearms? And I was so surprised. I sort of thought it should be a categorical exception, quite frankly. So I called the legal director and I asked him about it, and I said, when will we ever defend people who are carrying firearms? And so first of all, he pointed out, as I had heard before, I'm not sure this is accurate, and he wasn't either, because we've heard conflicting accounts, that the ACLU in the past had defended Black Panthers and other members of the Black Power movement when they were carrying firearms. I think what's disputed is whether they were loaded or not, but definitely they were carrying firearms. And he said two things. He said, number one, if there were first of all, if the firearms are specifically relevant to the particular message, such as people are demonstrating for Second Amendment rights, that should be a factor that would weigh in favor of defending them. And also if measures are taken to make sure that there's no danger, such as they're unloaded or other safety measures.
Thank you, that's very reasonable.
Thank you. Tom, thank you.
Although it seems that the tactic of creating false narratives and lying in public office has risen to new heights, the concept is nothing new. If you read Chernow's Hamilton, that's been a major part of our country since
Thank
its
you.
very beginning.
Yes. Thank you so much. And it was one of the points that I wanted to make in response to the first question. We tend to think that everything that we're dealing with now is worse than it's ever been. And the truth is, we've had lies and also on the polarization. You know, people now talk about echo chambers on social media. Well, I mean, we had pamphlets, we had newspapers that were explicitly partisan, and people would just read whatever, you know, was in accord with their views. And then the same thing happened with cable TV and with so-called hate radio. And I learned recently, what some of you may know, that it wasn't until the late 19th century, as a result of self-regulation, that mainstream newspapers developed with the hope of reaching a broader audience, not just appealing to a particular narrow partisan slice of the population. And so they adopted started press councils and had ombudsmen and adopted voluntary codes of conduct. And some people are suggesting that that kind of self-regulation is one of the steps that is taking place on the part of the social media. I'm certainly no apologist for Facebook, as you know from what I said earlier, but it seems as if all of the so what can we do, to go back to your question, Mark? I mean, one of the things we can do is that we can raise our voices as consumers. There's been a lot of pressure that's been put on these social media to drive out the Alex Joneses and so forth, and I think those of us who are concerned about free speech haven't quite raised our voices as much. But now Zuckerberg and others are responding to the criticism, and they're putting in place at least some kind of due process protection. So for the first time last year, they actually released what their standards are. And now they're moving in the direction of certain transparency and accountability reports. They're actually going to be setting up some kind of independent review mechanism completely outside of Facebook. I was recently invited to be one of the experts that they consult with, and how do we, you know, articulate our guidelines and how do we enforce them. So we may be seeing that kind of evolution.
Hi.
Hi.
I'm Robert. I had a
What's your
question-
name?
Robert.
Robert.
Yeah, I had a question exactly about what you referenced at the end just there. So people often say that, you know, large social media companies like Twitter, Facebook, can publish or refuse to publish whatever they want, which is of course true on legal grounds. But then they'll say, there's no legal question at all. And, correct me if I'm wrong, but like when I sign up for Twitter, I sign an agreement, right? And if I fail to abide by that agreement, they can kick me off the site. But they can also break their agreement if they
Yeah.
kick me off the site for reasons that they decide are important. But if they're not in the agreement, then that would be breach of contract or something like
Exactly,
that, right?
yeah.
So
Except, and I must admit, I'm one of a zillion people who hasn't read all of the terms of service. Does anybody do it? From what I've been told, and I think you alluded to this too, Robert, I think those terms say we reserve the right to change them, right? Even without notice. So it's kind of an unenforceable contract, if that's correct.
right, yeah, I didn't know that
Yeah.
line was in there. But I was wondering if so people, especially on Twitter, there are a lot of content creators like journalists who sometimes even their whole income depends on being
Yes,
able to publish through sites like these. So it can be really devastating for people
I
if they're,
agree.
quote, permanently suspended,
Yeah.
kicked off the site. And then sometimes, they try to appeal, it might not work.
Yeah.
And then they have no means of making up for that in any other way. So I was wondering, and along with that, some people will then say, this is not just being like randomly unfair, but there's some sort of systematic bias among the social media sites against a particular viewpoint or particular group. So I was wondering if you saw any role for legal groups like the ACLU or even more partisan groups to start like pressuring Twitter to engage, like suing them or to engage in legal discovery to pressure them to like add more transparency to their processes.
It's an excellent question, and I certainly think that basic procedural protections are really important, and a big coalition and diverse coalition of human rights groups, including at the international level, have adopted something called the Santa Clara Principles a couple of years ago. They were also adopted by the UN Rapporteur on Freedom of Speech, calling on these companies as a matter of self-regulation, but also, the enticement to them is that, consumers will put pressure on them, and if they engage in this self-regulation, they can ward off potential government regulation, which they're very much afraid of. And these principles are calling, it's not a complete cure, but it's calling for basic fairness, and there are basically 4 elements. Number 1 is notice of what your standards are. And I certainly know this, that in the terms of service, or they sometimes call it community guidelines, where they list what their standards are for what can be on and what can, they definitely reserve the right to change those at any time. And until recently, the only way you could get any information about what those standards were through some leaks to the media. And I think in response to leaks as well as public pressure, we're starting to see the social media companies lay out what their standards are. So that's happening, and that's a very important first step. Secondly, to give notice to somebody who is allegedly in breach of the standards, because people have been taken down and put into Facebook jail without any idea of what supposed standard they supposedly violated, and without any opportunity to challenge that. And so the opportunity to challenge and the right of appeal to an independent agency of some sort. And then I guess there are 5 principles. Regular reporting and transparency. How are you enforcing these on a statistical basis? How many enforcement actions have you taken? How many have you refused to take? What standards were violated? So at least we have some overall sense of what's going on. And that could just be a first step, but I think it would be a really important first step.
Yeah, hi, thank you. There's a lot of misinformation out there about Citizens United, the Citizens United decision. If I speak with someone who is in favor of overturning Citizens United, and I tell them, if Citizens United is overturned, it would allow the government to prevent the production and distribution of a movie, a documentary, for example, based on content. they say- and they say-
ACLU, nonpartisan advertisements on civil liberties issues.
Well, they say, no, it wouldn't, that's not what it's about. But of course, that was the exact issue of the
Yeah.
case. So could you please set us straight here?
Ugh, people may still disagree with the decision, but it is so badly misunderstood. And I think a lot of the blame goes to the media. These days, I have to say, just because I criticize particular exercises of freedom of the press does not mean I think the media is the enemy of the people. I think it's an incredibly important institution, and we have a right and responsibility to criticize particular exercises of that freedom. So 99% of the time, the decision is described as allowing powerful multinational corporations to flood the system with money supporting candidates for office. And it's never mentioned that unions also are protected. It's never mentioned that small, impecunious, not-for-profit corporations are protected, and the vast majority of public interest organizations, including the ACLU, which for that reason was a plaintiff in the case, would be silenced in effect by these restrictions. And the ACLU, by our own charter, never takes positions for or against candidates for office. But what was suppressed by the law that was overturned was what's called issue ads, when you're advocating for or against a position on a certain issue. But under the law, if you did so mentioning the name of a candidate for office, that became a crime. So if the ACLU did what we always did, which was calling on the then president, George W. Bush, take out radio ads, couldn't afford TV, take out, but broadcast ads saying, President Bush, you should repeal the Patriot Act because it's violating our privacy rights. And that would have been a crime. And as the president of the ACLU, I would have faced a 5-year prison term. Other examples that the Justice Kennedy's majority opinion gave were ads by Planned Parenthood in favor of abortion rights, ads by the Sierra Club in favor of environmental protection. So I explained all of this to my husband. He said, I don't think most people understand that that's what's at stake here. You ought to bring a test case to, so that you could challenge that particular application of the law. And I said, well, if I did that, I could face a 5-year prison term. And is that really a price worth paying for free speech? And he said, yes. So it's a very complicated issue, and I do think that part of the Supreme Court analysis might be questioned, but not the fact that those of us who choose to organize in corporate or union form should still have free speech rights to advocate on issues, and that that our ability to do so effectively is hindered if we're prevented from spending a certain amount of money, more than a certain amount of money to do that.
Hi. Thanks. My question is about the imminent threat standard and whether there needs to be maybe more work on how to interpret that, given how different communication is these days and the kinds of things that have turned out to be threats. And in particular, I was wondering what you thought about taking down the manifestos that these shooters have put up and how to deal with that kind of threat.
That's really interesting. So I certainly would support social media deciding to exercise their power to take down those manifestos, and I quite frankly don't know if they've done that or tried to do that. I know that they've certainly taken down violent imagery. I would defend their right to do that, and I wouldn't object. In terms of whether the government could do that, I would absolutely oppose it if I look at the historic record of what the government has deemed to be, to have, you know, a sufficiently bad tendency before we had the current standard. In fact, it's very interesting. One of the early cases did involve what was called a manifesto, and it was by a socialist organization or some left-wing organization that had a manifesto against capitalism, against war, against the military draft, and that was seen to constitute a threat to the government as a whole and a threat to the lives of people who were fighting in the military. Again, until we adopted the very narrow definition, people who were protesting, every anti-war demonstrator was in danger of being imprisoned. That was one of the reasons why the ACLU was founded in 1920, was 15,000 people were imprisoned for criticizing World War I. That was seen as posing a threat in this looser sense of the term. So I just think, you know, again, it's like, what is the lesser of two evils? There's a lot of that kind of language that does not lead to somebody committing a crime. And if we did punish everything that could or even has led somebody to commit a crime, we would basically have nothing published at all. I mean, what is the single work that more often than any other work has been blamed for both individual crimes and mass crimes is the Bible, right? And also the Quran. People have cited these books as allegedly justifying everything from individual murder and rape to attacks on whole other groups of humanity. And the same thing has been done with respect to movies, to novels. I mean, people have committed copycat crimes saying that they were inspired by Crime and Punishment. So yeah, there's a lot of connection between a lot of words and a lot of harm. And I think unless we really cabin government discretion to punish only those that have a tight and direct connection, it's going to be too dangerous to go beyond that.
There's a student who has had his hand up for a while.
Hey.
Hi.
This is sort of getting a little bit away from the whole constitutional issue, but just about your stance on how, while Facebook may have the right to sort of self-censor, that it shouldn't because it's too powerful an organization.
Mm-hmm.
Like, given that Facebook's sort of goal isn't necessarily to be a means of spreading political ideas, but instead a means of connecting people who want to meet on the internet, don't you think it's there? And given how it's been shown that opinions both to the left and to the right become far more extreme and polarized on the internet, don't you think it's their prerogative to sort of regulate it a little bit, or otherwise they'll end up sort of sacrificing their goal in favor of something they aren't even constitutionally mandated to do?
Yeah, can you tell me your name too, please?
I'm Aziz.
Aziz?
Yeah.
That is, it's a really important point, and I am very torn about this because I completely defend Facebook's free speech rights. I completely defend its goal as a business to make a profit for its shareholders and therefore to be concerned about what is going to be good for business. And exactly what you're describing, Aziz, is they want to create a community that's going to be, well, I'm going to contradict you a little bit. It's so complicated. They certainly have a right and a prerogative to say, we're going to design a product and a community that is appealing to the customers we want. The contradiction there is that studies continue to show that people are most attracted to the most extreme ideas. So if they truly wanted to do what is good for business, they probably would be propelling people more in the extreme direction. Now, Mark Zuckerberg's latest manifesto, and I'm not sure if he used that term, but that's how I think he actually did. He actually is saying we recognize that that is what people are attracted to, so we're going to try to create incentives to pull them away from the extremes, indicating that he feels some sense of social responsibility beyond just what is good for Facebook from a profit-making perspective. What I was trying to point to was the dangers. It sounds so good to have them kick off hate speech, but is there a way we can do it that is going to avoid the pitfalls that have been exhibited by every enforcement of hate speech standards by every enforcer, including the social media companies? I haven't given up on it, so that's why I agreed to participate in this undertaking, which I think is in good faith, help us to see how we can enforce these standards. And I would never say you shouldn't have standards at all. That said, I think it would be wonderful if we did have choices of social media platforms so that some people may prefer to have an opportunity to participate in a platform that is no holds barred, everybody can say everything, rather than all being driven to whatever it is that Facebook chooses to lay out as its standards. And here, one remedy, going back, did I get your name right? Is it Mark in the blue? Yeah, going back to Mark's point, one remedy that is seriously being considered including by some presidential candidates, is an antitrust approach, a pro-competition approach, that if a company has so much market power that consumers really don't have a choice for all practical purposes as to where they go for those services, that's a dysfunctional economic marketplace, and then it makes the marketplace of ideas dysfunctional too. So thank you for a very important point.
We are we're at time, and Nadine is actually going to be outside. Norwich Bookstore has a whole bunch of her books out there, and she's going to be out there for a book signing. So I hope you will, the people who did not get to ask their questions, I hope you will follow her.
I'd be happy to answer questions individually.
Yes, so thank you so much.
Thank you so much. Great questions. Thank you.